Okay, good morning, everybody, and welcome to our webinar, where for the next hour we will be discussing how to decide whether to settle or fight when faced with an employment tribunal claim. And thank you all very much for joining us this morning. I'm Diana Patmore, Head of People Relations and Policy at Moore Kingston Smith People Advisory, and I'm delighted to be joined by my colleague, Donal Moon, who is our Employment Law Specialist. Donal is going to start by sharing a real life scenario that one of our clients was faced with, and we will be asking you as attendees to vote on whether you would try to settle the claim or whether you would try to defend it. So listen very carefully, because as always with these situations, the devil is in the detail. Donal will then share the reasons an employer might choose to settle or defend a claim and what each process involves, with a view to helping you consider all the options and possibilities when or if you're ever faced with an employment tribunal claim. Donal will then recap the scenario and ask you again to vote, and he will then share the real life outcome with you. So please feel free to ask any questions by typing them in the Q&A function, and it will be my role to pose them to Donal. Any that we don't manage to answer live, we will try and follow up afterwards with you. This webinar is being recorded, and we will be sharing the recording and slides afterwards, as well as Donal's top tips on this subject. So without further ado, I'll hand over to you, Donal.
Thank you very much, Dinah, and thank you everybody for coming. I hope you find today informative and useful. So without further ado, I'll outline the scenario. So this is, by the way, was a real life case that we once dealt with. The identities have, of course, been anonymized in order to protect the innocent. So this is about a person called X, who was a manager with a company called, we'll call them ABC Limited, in charge of a team of case managers, and it was a professional firm. So X had long-standing health conditions, including, crucially for this scenario, back problems. She sustained an injury on the pavement outside the office when she was coming back from lunch, so nothing to do with her work. She told her manager she'd hurt her back, but she'd be all right. So typical sort of employee trying to be stoic and sort of soldier on, and she carried on working. But unfortunately, a few days later, she attempted to lift some boxes of files in the office, despite her manager telling her not to do so, and she injured her back again. So she was sent home. X's GP signed her off for 2 weeks with back pain following an injury. The GP then again signed her off for the same reason, because things didn't improve, but this time for 2 months. So you can see that the injury is starting to get a little bit worse. So X began to work from home with full support of the company, but the case management function began to fall apart. So things like disciplinary issues started emerging with the team. So in a sort of the cat's away, the mice will play sort of way. There were complaints from clients about missed deadlines and things like that. So as you can imagine, for a professional firm, this wasn't great. And the company therefore needed to decide what to do. So it ended the home working arrangement, as it clearly wasn't working out for the company. And X was then signed off sick. A director then assumed responsibility for X's team. But of course, that meant that the director was doing that in addition to his own responsibility. So was, of course, finding it quite tough to juggle both sets of responsibilities. So that caused something of a resource issue for the company. X underwent surgery to her back, which she was hoping would improve things, but unfortunately, it just made matters worse. Various medical investigations and meetings between ABC and X didn't result in a prognosis for return. Various adjustments were then suggested, some of which were to the physical features of the building, but none of those the company could do because it was an old listed building, and there were several other issues that meant that it couldn't be done. Home working was also then suggested as an option again, but that was rejected because it had already been tried and, as you see from the scenario, failed. And by this time, the condition had worsened and X was barely mobile. So what ABC did was they were keen to try and do as much as they could to try and see if they could get X back to work. So they hired an expert from an organization called Access to Work. And Access to Work came in and inspected the building to see what adjustments could be made. And they recommended installing a stair lift and installing an outside toilet. Company couldn't accommodate either because the corridors were too narrow. So it meant difficulties passing with people passing by. So they felt that that in itself caused a health and safety issue. And they also felt having an outside toilet would not be dignified for X. So they then got an updated medical report again. So again, following all the right things in terms of getting as much information as they could. But that still provided no prognosis for return. It just stated that things might improve if the company could implement the access to work recommendations and any other reasonable adjustments that have been recommended. So ABC, as you'll appreciate, was in a bit of between a rock and a hard place and had to consider now what it needed to do. So it considered all the information available to it and formed the view it needed to follow capability process and consider dismissal. It had tried and failed to make all of the reasonable adjustments that had been suggested and others that the employee had suggested herself. It couldn't make the recommended reasonable adjustments, and it felt that it had done enough analysis to be able to conclude reasonably that it couldn't do that, and there was no prognosis for return. So the company made the difficult decision to dismiss X for capability. And X then brought a claim for unfair dismissal and disability discrimination, amongst other things. Hand on heart, ABC didn't think it could have done any more. So it was therefore determined to defend the claims.
Thanks, Donal, for running through the scenario. If you go to the next slide, we have the poll now. So what we're going to ask you all to do is to vote in our first poll, which will be coming up on the screen now. So the question is, having heard the scenario that Donal's just outlined, would you try to settle or would you decide to try and defend this claim? Okay, I think everybody's answered now. Nope, just waiting for a few more. Yeah, okay. So the results of the poll, 46% of you would decide to settle based on what Donal's outlined, and 54% of you would decide to try and fight this claim and try and defend it at the employment tribunal. So more people would prefer to try and fight that. Donal, what are your thoughts on that result?
I think that's quite an interesting one. Fairly even, well, not even Stevens, but more people bullish about prospects and ready to fight this. I think that I think that is quite interesting. That's what that doesn't surprise me. As I say, hand on heart, the employer in this case didn't feel that they could do that that they could have done anything more. So that this doesn't surprise me at all. But some people, obviously moving on the settlement side, maybe on a commercial basis. But I think what will be interesting is to see, but after we've given everybody all the information to be able to make a decision either way, whether the needle shifts on that. I think that'll be quite interesting to see.
Yeah, let's see, Donal. So you're going to now talk about the reasons to defend.
Yes. Okay, so there are many reasons why an employer might want to defend a claim. So the first one, and I think probably the most obvious one, is strong defence. So we think we've got the strongest defence possible. We're very bullish about prospects here, so we're more than ready to fight. That's probably the most common one. Or we've done nothing wrong is the other way that you might hear that said. Insured. So some companies have legal expenses insurance that covers the cost, and they come in various forms, but they cover the cost of generally defending a claim, provided that a third party, usually a solicitor or a representative of some kind, assesses that you've got reasonable prospects of defending the claims. So that might reduce some of the cost worries for employers and mean that they're more likely to be bullish about prospects and want to fight, because they're not so worried about the potential costs to the company of having to fund a defense privately. No reward for wrongdoers. Well, of course, that doesn't apply in this scenario particularly because it's a health related claim, but I thought I'd throw this one in there in general because it's something that a lot of employers feel very strongly about. Why should we award an employee, for example, who has committed gross misconduct? Why should we allow someone to profit from their poor behavior? That can sometimes come up. The floodgates argument. So if we settle, then everybody else will think we're a soft touch, and they'll all want to sue us, hoping that we'll give them some money. And so regardless of what you say about, well, actually the settlements are all confidential, the employers can sometimes be nervous that the word will still get out there one way or another, and people will start to see them as a cash machine almost. It's not the money, it's the principle. So a well-known phrase, but that is something that some employers do. And I think a good example of that in recent years was Alan Sugar, who faced a constructive unfair dismissal claim from someone he hired following The Apprentice. It cost him £50,000 to defend the claim successfully, but he said on record that he'd rather have sunk his money into legal costs than give this person any money, because it was the principle for him. He felt she had a very poor claim, and why should he give her any money when he hadn't done anything wrong? Another potential scenario is where you've made an offer to settle. So, for example, you've explored that with the employee. You've made what you think is a reasonable offer, but unfortunately, the employee's expectations are unrealistic. So you end up being poles apart, and it's impossible to reach an agreement. So in those circumstances, you may feel compelled to fight the claim because settlement wasn't possible. Another one is time constraints. Sometimes companies almost get forced into having to at least partway defend a case to protect their position. And that can sometimes happen because an employee brings a claim, the tribunal serves it upon the employer, and they're supposed to have 28 days in order to do that, but there can be delays with post, there can be delays in tribunal getting the document out, which means that you've got much less time to consider your position and try and settle than you might like. But of course, naturally, if you've got someone professional to do your defense for you, they'll put it in the strongest terms possible, and you might read that defense and think, actually, I feel a little bit more bullish about prospects than I did before. I don't want to settle now. I actually want to carry on. I'm really confident in this now. So that can be another thing where time constraints can actually lead you down that path of thinking, actually, I feel much more bullish about this now that I've seen the defense in writing and it looks good. So I thought I'd give you a little bit of an overview of what defending a claim involves. So there's quite a lot to it. So you've got time on two things really. So time spent liaising with legal representatives to give instructions. So what do I mean by that? Well, when you engage a representative to help you with the defense, they'll want to know everything about the case in order to help them put your defense in the strongest way possible and prepare everything to give you the best chance of winning. But of course that takes time. You have to be able to explain everything to them verbally. There may be emails going back and forth, asking questions and responding to questions. And certainly with the defense, there may be, and this is bullet point 2 now, several drafts of the defense before everybody's happy that it's 100% accurate and ready to go. So in a case like this, the scenario that we discussed today, instructing medical experts can be an important aspect of it. Why? Because sometimes it's not admitted that the person's disabled, or it's felt that there's a need for further information about what a medic would say reasonable adjustments would be. And although you've got occupational health, although you've got access to work, it may be that a specialist in this particular health condition can shed further light on these things to help the tribunal make its decision. So there's instructing medical experts, and that's quite a detailed process, really. So you have to get all the records in from the GP and any potential specialists. And it's not just a case of picking an expert out and going with it. Generally, how this works with tribunals is you propose 3 experts to the employee's solicitor or the solicitor, and they choose which one they like from the list of 3. And then you draft a detailed instruction letter setting out what you want the advice on, so that it can help the tribunal make its decisions on key points. And potentially there may be follow-up questions if there's any areas of ambiguity or either party wants additional information. The next bit would be searching and disclosing for relevant documents, and that could be, if you've ever handled a subject access request, you'll know how difficult this can be, but it's a little bit more involved, because instead of just pulling off everything and saying, here you go, yes, I appreciate there's redactions and things like that with subject access requests, but with this, the obligation is to disclose relevant documents. So there's a lot more searching to it and filtering down of things. to try and get to those relevant documents. So it can be quite a long and drawn out process. Of course, your representative can help you with it, but yeah, there will be some time investment in pulling everything together. Now, this isn't something for you to worry about. This will be your unless you're handling a defence yourself. But if you've got a representative, creating a bundle of documents for the hearing is something they should do for you. But if you are doing this yourself, it involves essentially combining the two sets of disclosures, date ordering everything, and then putting it in book format to help the tribunal make its to give them a handy reference tool to be able to refer to documents that are in the witness statement. Reviewing and approving draft witness statements. So witness statements are the key documents that each of your witnesses will be using. So long gone are the days when witnesses used to read out their witness statements and then there were a couple of maybe follow-on questions. That doesn't happen anymore. What the tribunals do is what's called taking it as read. So and then they launch straight into cross-examination. So these are really, really key documents. You haven't really got much chance to clarify anything because you're launching straight into cross-examination. So any weaknesses can be exposed. So these can be key documents, and they can go through several drafts. They can run to say 20 pages in some cases, in more complex cases, but absolutely essential to get these right. So there'll be several drafts going back and forward until everybody's happy with them, and everybody's happy that it puts the case in the strongest terms possible. Quite likely, I mean, we always instruct barristers to represent clients at hearings, and generally speaking, the barrister will want, probably around the time when the first draft of the witness statement is done, they'll probably want to hear a meeting with everybody. They call it a conference with the witnesses prior to the hearing taking place, really so they can kind of advise on any potential weaknesses and strengths in the case, and also they can put obviously they can't coach you, it's against the rules, but they can sort of ask questions to try and make the witness statements as strong as possible. So that's usually a day to do that. And then, of course, you've got the hearing itself. So witness attendance at the hearing and cross-examination by the employee's barrister. So in a case like this, I would expect, I mean, generally speaking, simple cases can be 2 or 3 days. In a case like this, I would expect something between 5 to 10. Some hearings are longer, but I don't think this one wasn't. I think it was about 5 or 6 from memory. And then, of course, there's the costs. So you've got your time investment, and they estimate at the moment, I'm seeing that it's taking around 49 weeks to get to a first hearing cases at the moment, which is quite a long time. Some of that started during the pandemic, but I don't think that's showing any signs of abating. I think the backlogs have actually increased since then. So it could actually be worse now than 49 weeks. And again, as I just said, like, you can expect a hearing to be around about 2 to 5 days, possibly more in complex cases, multiple witnesses. And then there's something else to consider. You may not get a decision on the last day. Tribunals do attempt to do that if possible, but it's not always possible. Sometimes they have to go away and think about things, or the time runs out, so they don't have the time to do it. So you may spend some time waiting for a reserved judgment. So a reserved judgment is just a judgment in writing, detailed and setting out the findings of the tribunal. In terms of costs, I would expect defending a claim to cost around about £20,000 to £30,000 in representative fees. So that's the preparation of the case. And then on top of that, you've got barristers' costs of between possibly 10 to 15, but it could be more because they charge by the day. So for more complex cases with more days involved, it can cost more. And of course, it depends on the seniority of the barrister you use. Of course, their fees go up as they get more experienced. You've then got, if you lose, you've got the possibility of compensation. So that's basic award. So that's essentially the same as a redundancy payment, done exactly the same way, based on age and length of service, and capped at 643 per week. You've got loss of earnings potentially. In theory, if the employee hasn't found work, and that does depend very much on individual circumstances and the state of the job market, they could get loss of earnings up to the date of a hearing, and we've seen that it's taking about 49 weeks. and possibly future loss of earnings. If a tribunal is feeling particularly generous and they think that the individual will have difficulty finding new work, they could make an award of future loss of earnings as well. And potentially in discrimination cases, you've got injury to feelings, which is based on 3 bands of compensation. I won't go into those in too much detail at the moment, but other than to say that there's 3 bands and it's based on the seriousness of the discrimination. In a worst case scenario, you've got a discretionary award of aggravated damages, which can be up to £25,000. In most cases, that won't be the case that you get that an employee will get aggravated damages, but it's worth factoring into your worst case scenarios if it really exists, if there's been examples of aggravating features such as bullying and harassment. So things like that, or willful failures to follow due process in certain cases. Then you've got an uplift of potential, and again, this is discretionary, but a potential uplift of 25% for any failure to follow any relevant ACAS code. And I've put the last point, I've put costs award ? It's something that I think everybody should factor in when they're thinking whether or not to settle or fight a claim, just because it is possible that the tribunal could award costs. However, fair to say that is a worst case scenario, so I don't mean to scaremonger here. It's only usually awarded in cases where there's vexatious or unreasonable behavior by one or other of the parties. It's not just a given like it is in civil cases, but I've put it in there just with a question mark, just to say that it's something that could be factored in to decision making.
Okay, thanks, Donal. Thanks for running through all of those considerations regarding defending a claim. I think you might have stunned everyone into silence with those costs, because so far we've had no live questions come through, but we did have a question come in through. It kind of relates to this actually prior to the webinar, which hopefully you can answer for us, Donal. So it was, I've been advised by my HR advisor that we've not followed the ACAS code. And so we may be looking at a 25% additional uplift in compensation. How likely is this? So that's the question. And perhaps, Donal, for the benefit of everyone, you could briefly explain what's in the ACAS code, if that's possible.
Okay, so there are lots of different ACAS codes, and you can find them on the ACAS website. They're fairly long documents, so explaining it in great detail is probably beyond the scope of what I can do today. But I think what they'll usually cover is process and the way to deal with a specific process in a way that's reasonable and fair to the employee. So say, for example, in the context of this scenario, we're looking at capability. So it will be covering things like meetings, for example, and making sure that the employee has sufficient notice of meetings, making sure that they're informed about their right to be accompanied, and making sure that they've got the making sure, for example, and it might cover things like, for example, recording meetings and things like that, and whether there's the right to record and what processes need to happen around that, and who should do the what investigation should take place prior to any meetings, what information should be collected, what should be shared, that sort of stuff. And then if if a decision is made to dismiss for this reason, making sure that you inform the employee that they've got the right to appeal. So it's quite important to keep on top of these documents. And yes, most companies will have their own policies in place and procedures in place, but making sure that it aligns with what the ACAS code says is quite important. Now, in terms of the uplift, that's not a given, it's discretionary. Yes, it's something that employers should probably factor in as a worst case scenario, because I think if you don't, you kind of get a huge shock if you're told then that you have a 25% uplift. But what I would say is that it tends to, for the uplift to apply, the failure to follow the code has to be unreasonable. So I don't think you'd be expecting a 25% uplift for a mistake or an error, a genuine error. I don't think that's what these things are all about. It's about punishing employers who just deliberately throw process to the wind and decide to plow on with a course of action that's unfair to the employee. Yes, there might be an uplift of some kind, to make a point, but I don't think it would be as high as 25% if the failure is just an error.
Well, that's good to hear, Donal. I'm sure a lot of the people on this webinar will be relieved to hear that. I do have a couple of other questions that have come in. This one, Donal, thanks for sharing the average cost to expect when defending a claim. Would the employee have very similar costs? Because I'd be shocked if the level of costs alone doesn't put off more employees from raising a claim.
They could have. They could have if they're paying privately. That's quite possible. But again, going back to our slide, legal expenses insurance, for example, is something that a lot of employees have as well. And it can be bundled in with things like house insurance, home and contents insurance, or some credit cards as well have legal expenses insurance in there. So you might get employees who have, shall we say, alternative funding arrangements, or in the case of employees, you quite often get solicitors who are prepared to take things on a conditional fee basis. So that can sometimes be a useful method of them not having the same outlay that for example, a respondent employer would have. Yeah. So in theory, it can be actually much easier. You would think it would be the same, but it can be much easier for an employee to fund their litigation.
Yeah. Another question that's just come in. So it says, you mentioned that cross-examination by employees barrister. Is this always the case? I am aware some employees choose to represent themselves at employment tribunal.
Yeah, so it's not always a barrister. So employees can represent themselves in the same way that employers can. So if they are representing themselves, it would be them cross-examining the witnesses.
Yeah. Okay.
Rather than the barrister. So, and then sometimes what you get as well is if a judge has a question or a query, it tends not to be cross-examination as such, but they might have questions that they need responding to clarify their thinking or fill in some information gaps. So you might get the judge or one of the lay members weighing in at some point and asking some questions.
Yeah. Okay, thanks, Donal. That's all the questions that I'm going to give you for now. So I guess you're going to go through reasons to settle now, are you?
Yeah. So again, I think, going through some reasons an employer might want to settle, I think this is exactly the opposite, the polar opposite of the one that we discussed, where I think I've got a really strong defense, I've done nothing wrong. We've got a bit of a lack of confidence in defense here. So why might this happen, for example? Perhaps, and I think this is probably common to everybody in every walk of life, in every scenario. Sometimes self-doubt can creep in. You think you've done the right thing, but actually, I'm not so sure. Or someone, for example, like a barrister or solicitor or a representative has told you actually you may have messed up on procedure here somewhere. So you start to lose a little bit of confidence in the defense and think actually it might be better if this kind of goes away before it goes anywhere. Litigation risk. So no matter how strong you think a claim is, there's always a chance that a tribunal will take the opposite, won't see things the way that you do. That's always the risk in litigation. Remember, there are two sides to every story, and unlike, I mean, the tribunal won't know you. They won't know your firm. They won't know the steps that you take to kind of be as friendly to employees as you could. So there's every chance as an impartial observer, they could take a different view to the one that we would prefer them to take. So that's always a possibility, and some employers are kind of more alive to that than others, and in some cases they've actually been on the wrong end of it and think actually, we're well aware of the litigation risk here. So it could be they take a view right from the outset, maybe best to consider settling here. Could be an option. There's a perception with some employers that employment tribunals are too claimant friendly, so they always side with the employee wherever possible. I don't necessarily agree with it, but it is a view that I've heard before on several occasions. And I think, just to kind of even the score, I think employees who've lost tribunal claims tend to think that employment tribunals always side with the employer. So I think that's just one of the hazards of being in the employment tribunal system, that nobody's ever happy if they lose. And there is this perception that goes about that tribunals are either friendly in one direction or the other. It could be that key witnesses have left the company or are nervous. So that does sometimes happen. You get all your witnesses lined up, you're ready to go, and then people leave. And then there's kind of nervousness starts to develop about what will they do. will they be willing participants in this process, or will they do everything they can to try and avoid being willing participants in the process? In which case, do we need to try and get witness orders to compel them to attend? And if we do, what's the risks of that? For example, we might not know what they're going to say. We might not have the chance to do a witness statement for them. They could end up being hostile to the company. Or it could be that they're just particularly nervous and they're aware that they are going to be cross-examined and they don't really fancy the experience. So an employer might form the view, well, actually, I don't know whether these witnesses are going to stack up in the witness box. Even though we've got a great case, it could be that the nerves get the better of them on the day. It could be a commercial, and I think the 2 points are kind of linked, really. Two next points are kind of linked, really. It could be that you just want to do what you do best and run your business. You don't want a year's worth of time invested in defending tribunal proceedings with letters going back and forth and instructions and me on the phone saying, like, can you give me instructions on X, Y, Z and things like that, and then can you check this draft, can you check that draft, can you give me this, can you give me that? It could be that's not what you want to do. You just want to crack on with running your business, and that's kind of the commercial view of things, I suppose. And that goes into what I said. So the opposite, it's not the principle, it's the money. And then it could be, and this is something I've seen before, it can be a condition of your insurance cover, that you make an offer to settle. So when does that generally happen? When a third party representative assesses the claim, or the defense rather, as having no or not reasonable prospects of success. It can be some insurance, not all of them, but some insurance policies can say that your cover will continue provided that you make a reasonable offer to settle and it's rejected by the employee. And if you don't do that, then you're kind of on your own. You can choose to pay privately to defend the case, but otherwise the insurance cover would be withdrawn. So for some employers again, might, going back to our fighters, might say, well, it doesn't matter, I'll pay it privately. I'd rather sink the money into legal costs than settle, even if it is via the insurance. But others might think, actually, do you know what, we thought we were covered by insurance, but now that's not the case. It might make commercial sense to settle at this point. So what does settling a claim involve? So there's two ways that a claim can be settled. Number one is via the traditional settlement agreement. So if any of you've ever seen one of those before, it's a detailed contract setting out the terms of settlement. And it contains lots of legalistic terms that I won't go into today, but it essentially settles off and bars any claims. So those can be existing or potential claims. So the process would be, you draft an offer letter and a settlement agreement. The employee then, assuming you can agree on a figure, then takes that agreement to a solicitor. Then there'll either be agreement straight away, which is fantastic, or the solicitor will come back, or the employee, if you're dealing with them directly, and try to negotiate and agree the terms. And then, of course, they have to have advice from a solicitor to make this legally binding. So and then hopefully you'll be able to get the agreement back without too many difficulties. But in terms of the costs, it would be the agreed settlement amount, so whatever you can agree on, plus fees of around, I would say, £1,700 to £3,000, in terms of instructing your representative to draft the agreement, draft the relevant correspondence, and then do the negotiations on the terms for you and make any necessary amendments, plus solicitors' fees. So when you draft a settlement agreement, and you obliged to pay something towards the employee's legal cost of taking the advice, because after all, you're asking them to sign an agreement saying they won't bring any claims or they'll withdraw their claims. So generally speaking, it's not a high amount necessarily, but it would usually say something around £500 plus VAT, based on recent case law. But I have seen solicitors ask for more. So of course is much more common when you've got an employment tribunal case either being threatened by an employee, or it's already in train and you're trying to settle it. is an ACAS COT3 settlement agreement. So ACAS is the government body that has responsibility for being an intermediary, essentially, where there's a dispute between employer and employee. And what they'll do is they'll act as an intermediary and try and resolve that either without recourse to tribunal proceedings in the first place, or to settle off any existing tribunal claims. So how this works is you would negotiate with them via an intermediary, and that can be done via telephone, it can be done via emails. But it's essentially one party approaches them, makes an offer, and then they go away and talk. So there's no direct contact really. That sometimes there is. Some parties choose to copy each other in, but generally speaking, it's all done by passing messages onto ACAS and back again. And in the hope of agreeing a figure. And once you've agreed a figure, then you draft and negotiate settlement terms. And so an ACAS settlement is a kind of a bridge version of the traditional settlement agreement that I mentioned a few moments ago. It's quite short, really, and it, in terms of the costs, it would be the agreed settlement amount and plus fees of around 500 to 750 in terms of getting a representative to do all the negotiation and drafting for you, and no solicitors' fees, because it's just part of the ACAS process. It's not a traditional settlement agreement. Assuming you're able to agree everything, and all the parties sign, then generally what happens is if there's a tribunal claim ongoing, ACAS will write to the tribunal and say a binding settlement has been reached, and that will be it. The case then comes out of the list for any hearings, and no parties don't need to attend, and the case then vanishes for all intents and purposes.
Okay, thanks, Donal. Definitely from my point of view, having listened to you, settlement seems like a much more attractive prospect when you look at it compared to what's involved to defend a claim, I've got to say. Just again, feel free to put questions in the Q&A as and when you've got any attendees, please. In the meantime, we did have a question relating to this, Donal, regarding the insurance companies beforehand. Our insurance company is applying pressure on us to settle a claim. What is the point in having legal expenses insurance if that can happen? And how can I respond if I don't want to settle?
Yes, well, and this is something I remember when I was a solicitor in a firm. We used to get that quite a lot. Why should we settle? We don't want to settle. We've done nothing wrong, and it generally happens, as I say, when it's been assessed that you don't have reasonable prospects of defending a case. And of course, you could. So there's a number of things you can. There's a number of things you could do if you wanted to. If you were determined not to settle. So number one, you could ask for a second opinion from the solicitor who's assessed the case as not having reasonable prospects, and see if that might change, if the views might change, if you've got any new information to put their way that they can consider. So that might change things. The other one is you could try and contest it with the insurance company. I don't know how successful that would be. I think usually it's just based on the terms and conditions of the policy that you have, but it might be worth doing that and asking them if there's any other ways that you can handle this. But the other one is, I suppose, to accept that this is the case, and accept that you may well have to pay privately. So in terms of what the point of legal expenses insurance would be, I accept that this is a kind of position that many employers take, or why should we have it if it just gets pulled? But it is, again, I hate to make the analogy with car insurance, but it is a little bit the same, because it's cover provided in accordance with certain terms and conditions. So if those if it's a term of those terms and conditions that if you're assessed as not having reasonable prospects, then you have to try and make an offer to settle, and that's unfortunately the terms and conditions that you kind of have to abide by. But there are other types. I think there are other types of policies. I mean, I can't really advise on the terms of specific policies, but I'm aware that there are others that don't have that type of arrangement.
Okay, thanks, Donal. Hopefully that's answered that one. I have had another one come through about the ACAS COT3. So on the ACAS COT3, do they consider the circumstances of the claim for settlement purposes?
In what way? Do you mean what the claim is exactly, or?
Well, that's all the question says, but I guess, yeah. So I guess, does ACAS consider all the circumstances of the claim when they're looking at settling under the COT 3, or?
Sure. I mean, essentially what you would do is I think I see where this is coming from. So yeah. So when I call ACAS on behalf of a client, I would generally put the client's case in the strongest possible terms before putting forward any offer to settle. So yeah, I mean, it varies from case to case. Some employers will just say, we want to make an offer to settle. Here's the offer. So that will be as much as the ACAS officer knows, apart from having, but they will have the claim and the defense at their disposal because the tribunal gives it to them. So they'll know the facts. They'll be aware of the facts of the case. And it may well be that there's been some conversations with them about the facts of the case before the tribunal proceedings began in early conciliation. So they'll know the basics, but it's open to the employer to be as minimalistic or as detailed as they want. Really, you could sort of say, here's my arguments and here's why I'm making an offer to settle of X. So yeah, they certainly can do. They wouldn't necessarily be recorded in the agreement, except to the extent that it says what claims are being settled. But yeah, you can certainly give them as much detail as you want.
Yeah.
And sometimes it's helpful because it backs up your arguments as well of why you're making a specific offer.
Okay. Thanks, Donal. There are a couple more questions coming, but I think I'll save them for the end, after you've done the next part. So you're going to now recap, aren't you, on the scenario for everybody, so that everybody can then vote again and see if anyone's minds have been changed.
Okay, so this is a much shorter version of the scenario I gave you earlier. So it's a manager with ABC Limited. She had various long-standing health conditions, including back problems. She suffered from an injury, which was made worse by lifting boxes and then by corrective surgery. Working from home was tried but found to be unsustainable, and no physical manager meant strain on others and all sorts of issues, with the case management function falling apart until ultimately a director was appointed to do the work in addition to his own, but that of course put strain on him. Reasonable adjustments were investigated, but weren't considered possible due to various factors, including physical building constraints. And there was no prospect of return without those adjustments being made. So, yeah, okay. So I think,
have we got the next slide? This is, yeah, the poll. Okay. So for our second poll, obviously now you've heard Donal run through the merits of settling and the merits of defending a claim and what that involves. We'd like you to vote again on whether you think you would try and settle this claim or fight it. So there's a poll again up on your screens now. So if everybody could just choose an option. Okay, there's still a few more people to vote. Okay, I'm going to close the poll now and share the results. So 74% would now settle, as opposed to the 26% who would choose to fight. I'm not sure that everybody got a chance to put their vote in there, but you get the general gist, Donal. So what are your thoughts on those results?
That's quite a needle shift. It really isn't, yeah. compared to what we had at the beginning. It's unsurprising, really. But there's no right answer to this. And I think if, imagine, for example, I've given you given people a completely different scenario. The answer may still have been fight at the end of this.
Yeah.
Or it could have been settled. It depends. And people have different views. There's no right answer to this. But I think the most important thing is having all the information at your disposal about the pros and cons of each option to be able to make a value judgment. And you can do that, of course, in the case of attendees, they won't be dealing with this case, they'll be dealing with their own case. But at least if you've got all this information, you can kind of at least think about all of these things before you make a decision. And it kind of I think it helps. It kind of takes the emotion out of doing that. So once you've got past we did nothing wrong, and or we or the fear of I don't want to go to a tribunal. Once you stripped all those out and looked at all the other things, I think you can approach this with a much clearer head. But that it doesn't surprise me. So
No,
but
it doesn't
maybe
surprise me either. I would definitely have changed my mind too. Okay, so thank you everyone for voting. So are you going to share the actual outcome now, Donal, before we get onto the final Q&A?
Yeah, so in this case, the employer unfortunately did lose. So there were a number of things that kind of happened. So one witness couldn't attend and relied on a written statement, which is fine. You can do it, but unfortunately, where you rely on a written statement, you're not there to be cross-examined. That can mean that your evidence is given less weight than it could otherwise have been, because it's not been tested under pressure. The judge made clear that they felt the employer hadn't gone far enough with reasonable adjustments. So despite all of the work that the employer had done, they were dropped the bombshell after bombshell by the judge saying, why didn't you do this? Why didn't you do that? Why didn't you do the other thing? And it's like, but we did. And it's like, well, not enough. Why didn't you do it? Why didn't you do that? So it was, it was a really, it was kind of it was a bit of a bit of a shock, really, but for the employer, I think. Because and then a key witness under pressure again in the witness box, and this is something you can never control. A key witness who was at director level said, actually, thinking about it, I think we probably could have done a bit more. So and again, you might well have been able to get, with the judge making those points about thinking the employer could have done more. Those are kind of devil's advocate points of where the judge might be coming from, and they're open to persuasion. But once you then get a witness folding under pressure and saying, well, actually, I think we could have done more, it kind of goes, okay, so that's kind of confirmed what we were saying, or where we were thinking this was going. And then, so what happened was the case was set down for what's called a remedy hearing to discuss compensation. And the case settled for a six-figure sum before the remedy hearing. So yeah, the employer, and hand on heart, remember advising on this throughout the way. We didn't think the employer could have done any more than they did, but a series of things happened that meant that they lost the case. But at the same time, as I say, these are things you can't control really, and it's all quite fact sensitive.
Yeah.
But an interesting result, I think. It wasn't the one that the employer was expecting here. So
no, you can see that. Well, thanks for sharing that with everybody, Donal. Actually, I was going to ask, just out of interest, because I wasn't around, I don't think, when this case came up, but did they appeal the decision? Did the company appeal the decision?
No, they did look at it was looked into. It was looked into, but the difficulty with appealing is the only way you can do that is if the tribunal made an error of law. You can't appeal a decision generally you can't appeal a decision just because you think the tribunal has made the wrong one. There has to be a mistake in applying the law, or the decision's perverse, which means no reasonable tribunal could have come to it. Of course, everybody who loses a case thinks that's the decision was perverse, but it's got a specific legal meaning, and it's really hard to prove. So in the end, it wasn't worth appealing. It was just and of course, there's the matter of more costs and more time swallowed up with dealing with the case if you appeal as well. So
yeah. Thanks, Donal. Okay, so we're on to our final Q&A. I did have, if you'd like to go to the next slide, Donal, so we've just, so everybody can see we're in the Q&A, so encourage people to ask more questions. We have had a few that have come through already, though, that I'm going to cover now at the end. So sorry if I missed this, but could you clarify the maximum value of unfair dismissal compensatory awards and how those change where discriminatory dismissal is proven?
Yeah, sure. So that there is off the top of my head, I can't remember the exact figure. I can look it up. But essentially with there is a maximum compensation for unfair compensatory award for unfair dismissal, but it doesn't apply where the dismissal is discriminatory. That takes the cap off the compensatory award.
Yeah.
But you're looking at basic award, which is like a redundancy payment based on age and length of service, and it's got exactly the same calculations and exactly the same cap. There's a cap on compensatory awards, and again, I can't remember that. I think it's around about. I looked this up yesterday. I think it was around about the 105k mark, but I will look that up and give you the figure. And then, yeah, but it does, again, it doesn't apply in these sort of discriminatory or automatic, any dismissal, in fact, that's kind of seemed to be automatically unfair.
Yeah. Thanks, Donal. Another question, does ACAS provide a binding judgment? What if both parties fail to agree?
Yes, so ACAS, it's not a judgment, it's a settlement that they do. So it's a type of settlement, so it sort of stops the claim in its tracks by agreement between the two parties. And yes, it's binding. And what happens is once everything's been agreed, if you can agree if you can't agree a figure, if you can't agree the terms, then ACAS then bows out and the case proceeds.
Yeah.
If you do agree, then they write to the tribunal. They issue you a paper version. The claimant signs first, so the employee gives it to the employer, who then signs, and that's it. But essentially, as soon as you have agreed on the terms, in principle, ACAS will write to the tribunal and they will email the tribunal and say a binding settlement has been reached, and that will get the case removed from the list. It's gone. That's it. So, and the next step usually is what I do after that is try and apply for dismissal upon withdrawal, just to kind of put it to bed once and for all.
Yeah. Great, thanks, Donal. I've got a couple more questions which are quite specific, but we'll run through them. So one, is it easier to dismiss during probation for underperformance? And what if the employee is on long-term sick? So this kind of a little bit relates to the scenario, but not exactly. What are your thoughts?
Well, yeah, in theory, it should be lower risks to dismiss someone who's got under 2 years service. And I say in theory because if someone's got long-term sickness already and they've got less than 2 years service, that long-term sickness could be a disability. So, and bear in mind that the 2-year qualification period for claiming unfair dismissal does not apply to automatic unfair dismissal. So in theory, an employee who is dismissed for discriminatory reasons, in this case potentially disability, could bring a claim from day one.
Yeah.
So I like to say in theory it should be low risk, but it might not be depending on the facts of the case. It kind of, yeah, you'd need to analyze a bit further to see what the risks are.
Depends on what the long-term sickness is all about, really, doesn't it? Okay. And then another question, which is quite detailed. So a new member of staff joined recently and immediately disclosed chronic health issues, which prevented her from doing parts of her job. We have tried to accommodate her, but she is frequently absent and her work is of poor quality. We have documented all of this and followed ACAS guidance, but she's now on long-term sick leave. She is still on probation. Similar question. Is it easier to dismiss her?
So in theory, yes, but in theory it should be because of the short service. However, there may be some further investigations you go through here because of the health condition to see whether it's safe to do this. Because if it turns out to be a disability, and the reason, for example, for the poor performance is linked back, and the poor attendance is linked back to the disability, she could potentially bring a claim without having to have 2 years service first. So I'm not saying it can't be done, but it sounds like there's a bit of investigation that needs to be done first before you can establish whether it's safe to proceed down that path.
Yes, no, it's almost the same, isn't it, as the previous question?
Yeah, I think so. Yeah.
Yeah, there needs to be some investigation clearly into the health issues and any reasonable adjustments that might be able to be accommodated. And if they can't, and again, like the scenario, you feel like you've done everything you can, then you might be in a position where you can safely dismiss in the probation period. But yeah, it all turns on the facts, doesn't it, Donal, as always?
Yes.
So
yeah.
anyone who's got any
I
specific...
have the figure. Sorry to interrupt. I have the figure for the exact figure. It was 105,707 is the compensatory award cap.
Okay, brilliant.
But bear in mind that doesn't take into account also the potential aggravated damages award up to 25k and the 25% uplift. That's just the cap before those things are applied.
Yeah, great. Thanks for that, Donal. I have another question that's come through. If someone is unable to attend any performance review because they are sick, how are we meant to go through the process?
I would probably postpone the performance review until they're well enough to attend. There was actually the funny enough, there was a case about, I appreciate in saying this was a gross misconduct case, not a performance case, but it's somewhere where an employer just crashed on with a gross hearing. They didn't really believe the employee was sick, so I don't think there's any suggestion here that that's the case, but they thought that the employee was throwing a sickie, so they just cracked on with the disciplinary and dismissed, despite the fact that he was signed off with a medical note, and they ended up paying £1,177. So of course it doesn't sound like much, does it? But it's like the annoying part of it was that the tribunal then said, well, look, you had a really strong reason to dismiss, potentially, if you but you messed up by going ahead while he was on medical. So my advice with things like this is the safest route is always going to be postpone until the employee is well enough to attend. At some point, if it keeps going on, you may have to consider moving things forward, in which case one of the things you could do is address it as I suppose you might have to address performance / capability as dual processes. But yeah, so I think in an ideal world you'd postpone until the individual's ready enough to attend.
Yeah. And obviously if it keeps going on, like you say, then you need to think about, okay, can we actually still do this? And it depends as well, I guess, isn't it, whether the sickness is related to the performance as well, which, in
again,
this case,
that goes back to what we were saying before, doesn't it?
Sure.
So yeah, and if it is, then there could potentially be a claim in there, so to be careful of.
Yeah. Okay, well, it looks like, unless anyone else has got any other questions, it looks like we've answered pretty much all of them. And so I will just wrap things up by saying thank you very much, and we hope that you found it useful and informative. And thank you very much, Donal, for sharing your insights on this topic. And thanks to all attendees for joining us and sharing your own thoughts and in voting and asking us some questions, asking Donal the questions. If anyone has any questions that we haven't managed to answer during this webinar, please feel free to contact Donal afterwards. His contact details are on screen now. Donal, are you going to put your contact details up? Yay, there we go. If you could complete the feedback form, we'd be most grateful. And if you'd like to be contacted by Donal, please indicate this on the form as well. Thanks again for joining us. Please look out for future webinars that the People Advisory team will be running, and we look forward to seeing you again.